Good morning, everyone, and good afternoon as well, depending on where you are in the world. Thanks very much for tuning in for this morning or afternoon's session or webinar. I'm going to, in the next hour or so, try to cover some of the key themes and lessons from the past year in terms of developments in construction law. For those of you who might want to share this later on with other colleagues who can't join today, or if you might have to drop off a bit earlier because you've got other meetings to go to, don't worry, we are recording this session, so we will share the video and recording of the session afterwards. So as well, don't worry too much about taking notes. There's quite a lot that we have to cover, so you will be able to revisit some of this. And I also will be publishing what I will summarize over the next hour in a construction law review, which I actually do every year. So there will be a written version of this webinar. And indeed, some of it is actually covered in some of my past annual reviews as well. So you will be able to revisit a lot of this later on. So again, it's good to see you all, albeit only on the other end of the screen. I know some of you are probably familiar faces, and especially good to see you as well. So over the next hour or so, I just want to cover a few themes with you, and I'm just divided that into sort of 6 particular topics. I'm going to start with every common lawyer's worst nightmare, which is the issue of good faith. I'm just going to talk briefly about some of the sort of recent developments in that area. And then I'm going to move on to something sort of slightly related, but something which is sort of a bit different, which is ADR clauses, or as some of you might know them as DRP clauses. So there's been some developments in terms of the enforceability of ADR clauses, so I'm sure it will be quite relevant for many of you who are involved in construction disputes, as they are quite popular. We'll then move on to something which is different from all of those topics, which is liquidated damages and then causation and delay. So I'll talk a bit about sort of developments in terms of delay cases and delay claims. Then we'll move on to talk about the fire safety and structural safety defects aspects of developments over the past year. For those of you who are based in the UK, that will come as no surprise. For those of you who are sort of dialing in internationally, that is something which arises from some of the statutory changes made to the Defective Premises Act as a result of the Grenfell Tower incident some years ago. So we'll cover a bit of that. And then finally, I will end with some observations on recent trends in decisions regarding the enforcement of adjudication decisions, which I suspect will be more relevant for those of you who are practicing in the UK. But for those of you who are from other jurisdictions, you may have sort of similar sort of statutory procedures similar to adjudication, or if you do not have that, then at least some of that might be relevant to you as well when it comes to the enforcement of potentially arbitration awards, for example. So without further ado, I'm going to start with the first topic, which is good faith. Now, it should come as no surprise to any of you that there is no principle or no general principle of good faith in contract law, at least in English law at the moment. It might be different from in some other common law jurisdictions. But certainly, for instance, if you look at the Supreme Court decision back in 2021 of Pakistan International Airline, that was where the Supreme Court actually confirmed once again, as did many courts before that, that English law does not recognize a general duty of good faith. But that doesn't mean, of course, as we all know, that there can be no implied duty of good faith in particular contracts. So a lot of you will, of course, have come across cases such as Yamseng, where the court has established a principle that in relational contracts, you would be able to imply a duty of good faith. Now, over the past year, there have been 2 Court of Appeal decisions, not just one. So it's like London buses. You either have no cases on good faith, or you get 2 together in 1 year. And those Court of Appeal decisions actually do help clarify some of the principles, or at least summarize some of the principles regarding the implication of a duty of good faith. So starting with Candey Limited and Bosheh, that was not a construction dispute per se, but actually the principles enunciated in that decision is actually quite relevant in terms of the sort of ingredients which you would want to look for when trying to decide whether there is an implied duty of good faith in a construction or infrastructure contract, or indeed in any contract. That particular case actually relates to a CFA, so a conditional fee agreement, which is a retainer between the solicitors and their clients. And the question was whether there was an implied duty of good faith in that agreement requiring the client to settle the case, or settle the case on terms which would have allowed for the recovery of solicitors' costs. And the allegation was that there was a breach of that duty because the client settled on terms which precluded solicitors' costs. Now, Lord Justice Coulson, who, of course, as many of you know, was a TCC judge, and so his approach to this sort of question would be very relevant to construction disputes more generally. He actually rejected the case and rejected the attempt to imply a duty of good faith. And in doing so, he's provided a very helpful summary of the principles which are relevant. He emphasized, first of all, that the mere fact that you have a relationship which is long-term does not make it a relational contract. So what is required? And he actually endorsed a sort of checklist or menu of ingredients, which was actually proposed by Mr. Justice Fraser a bit earlier in 2019 in the decision of Bates and Post Office. And he said that that was a helpful sort of sense check of what relational contracts should entail. Of course, that's not meant to be an exhaustive list, but nonetheless, it's a helpful checklist. And then on that basis, he concluded that because the conditional fee agreements, albeit it was a fiduciary relationship, didn't require any high degree of communication or any high degree of investment from the client or any elements of exclusivity between the client and the solicitor. There was basically no sort of implied duty of good faith because it was not really a relational contract without those important elements. If you translate that to the construction context, think about sort of the more usual building contracts, or run-of-the-mill building contract, that probably wouldn't require an implied duty of good faith, even though it might be a lengthy one, which lasts for a couple of years. On the other hand, if you think of an infrastructure project or an infrastructure contract, a bit like a PFI contract in the UK, where you might have 20, 30 years, you might have a high degree of investment from different funders, from the contractor itself, then you might be getting closer to the territory of an implied duty of good faith. And we have seen the court implying a duty of good faith into that sort of PFI contract, such as, for instance, in the UBB and Essex County case, where it involved a waste-to-energy plant being built for a public authority. So that's Candey and Bosheh and the takeaway from that. We then move on, of course, to the question of, okay, well, when you do have a duty of good faith, what does it actually mean? The Court of Appeal decision of Ray Compound Photonics actually addresses that quite helpfully. It's worth bearing in mind that in this case, the court actually considered the contents of an express duty of good faith, but there's no reason why this doesn't also translate to, at least depending on the contract, translates into the contents of an implied duty of good faith. And what is important from this case is that the parties actually tried to argue that an express duty of good faith in a sort of shareholders agreement actually only precluded conduct which was dishonest. So basically trying to equate bad faith with dishonesty. So that's quite a high threshold, as most of us would know, because to show dishonesty, you need to show that there is some degree of untruthfulness or sort of lack of belief in the truth of certain facts. It's almost like proving fraud, basically. But what Lord Justice Snowden very helpfully clarified after looking at all the cases, including very well-known cases such as Mid-Essex Hospital and Compass, he clarified that the authorities don't establish the principle that good faith only means acting dishonestly. Rather, what good faith means is that you can't act in bad faith. Now, it might sound a bit tautological, but actually, if you think about it, what it means is that it precludes any conduct which might be regarded as commercially unacceptable or unreasonable to honest people, or things which might seem sort of arbitrary, capricious, or a bit opportunistic. So we're getting into the territory of actually looking at almost things like unconscionability or unreasonableness in conduct and any sort of attempt to exploit a party improperly, for example. So for anyone who tries to sort of confine the duty of good faith to the concept of dishonesty, Ray compound photonics is really, from last year, a good clarification that that would probably not be the case unless the contract actually quite specifically confines a concept of good faith to the principle of dishonesty. So that's all about good faith in a nutshell from the past year, I would say. Then we're moving on to ADR clauses, which actually, to some extent, is slightly related to the concept of good faith, because we do see from time to time certain ADR clauses which incorporates the concept of good faith by requiring parties to negotiate or mediate in good faith, for example. Now, previously, there have been cases in the TCC and the commercial courts showing a tendency to give effect to these multi-tier ADR clauses and to give effect effectively to the parties' intentions where possible. Which is then sort of quite surprising for us to see in the past year, both 2022 and 2023, to see the courts actually moving a bit away from that and being quite willing to strike down an ADR clause where it is actually shown to be inoperable. So one might think that the courts might strive to give effects to an ADR clause where possible, but it is clear that actually where it is not possible to do so, the court will not be shy to strike it down. And the case in point is the Children's Ark Partnerships and Kajima decision, and that was in the TCC last year and then in the Court of Appeal this year. So there are actually two decisions to read if you want to sort of read up on this particular subject. The short sort of summary of the TCC decision is that basically Mrs. Justice Joanna Smith decided that the ADR provision in this case was unenforceable, and therefore the strikeout application, which was based on the non-compliance with the ADR provision, was dismissed. The reason for that was really quite simple. This was a PFI contract, so there was a multi-tier sort of dispute resolution procedure. Part of that procedure required the parties to refer the dispute to what is called a liaison committee. So the concept of a liaison committee wouldn't be too sort of unfamiliar to all of you who have been doing some bits of sort of PFI or infrastructure work. But basically what it requires is that there has to be sort of a committee with representatives from the employer and from the project company in a PFI contract, and also the contractors, in order to sit down and resolve the dispute. That would be the usual type of liaison committee. What is peculiar about the liaison committee in this particular contract is that the liaison committee did not actually include the building contractor itself, or representatives from the building contractor. So it was a committee consisting of representatives from the local authority upstream, and then also the project company, so Children's Ark Partnerships in this case, but the building contractor, who was the sort of party to this building contract, was not involved in that liaison committee. And more importantly, there was no procedure in the contracts, no set procedure or rules, which tells you what the parties need to do once there has been a dispute referred to the committee in order to resolve the dispute. The problem is that the contract actually requires the parties to go through this process, and the right to commence legal proceedings only arises once the dispute has not been finally resolved by this liaison committee. But the problem is that you can't actually tell when the committee has or has not finally resolved the dispute, because there's no set time frame, there's no real set procedure. And the TCC basically decided that this was too uncertain to be enforced, and therefore they will not give effect to this provision, even though it's quite clear that it was intended as a condition precedent to the commencement of legal proceedings. This then went up to the Court of Appeal this year, and somewhat unsurprisingly, the Court of Appeal actually agreed. And Lord Justice Colston agreed with the TCC that the liaison committee was what he called a fundamentally flawed body, which couldn't resolve a dispute between the parties amicably, actually couldn't even fairly resolve the dispute, because Kajima, being the building contractor, is not even involved in the liaison committee, and it's not clear whether it would have any entitlement to make representations, or if so, how. There is, in fact, a real problem that there might be an issue of actual perceived bias, because there's only a committee which almost sits behind closed doors, involving the sort of local authority at the very top of the chain and the project company only. So all of that meant that the dispute resolution procedure was not enforceable, and the mere fact that the procedure actually says that the party should try to resolve the district within 10 days of referral doesn't mean that it's a set time frame. It's sort of purely aspirational. And again, there is no way for the courts to sort of infer when this procedure should come to an end. And the court was not willing to actually just step in and try to fill in the gaps for the parties where they haven't actually legislated for a sufficiently certain procedure. So on that basis, the Court of Appeal decided that the TCC reached the correct conclusion. It's worth very briefly mentioning that because of the nature of the remedy being sought, that being a strikeout, I think it probably made the court even more sort of vigilant in terms of deciding whether they should actually grant such a relief, because the thing was that in this particular case, if the claim was struck out because of non-compliance with the DRP, that would have meant that the claim would have been time-barred, or at least some of those claims would have been time-barred due to limitation. So the courts sort of considered whether a strikeout would be the usual order in these sort of cases, or would it be a stay of proceedings, which would be the more usual order. And Lord Justice Coulson said that it's not that in every case that only a stay would be granted, and that a strikeout would be inappropriate. But in most cases, the court would have to consider whether there's been any unreasonable conduct leading to the delay in bringing a claim. And in this case, there was no such delay, because there were very good reasons why the claim was only brought when it was, which was that the parties were waiting for the remedial works to the defects to be done before the claim was litigated. So that was the reason why it was brought so close to limitation, and that itself was not unreasonable. So a strikeout in this case would not have been appropriate in any event. So quite a helpful sort of guidance on the principles relating to the remedy you would get as well, even if there were a non-compliance with an ADR clause. So that hopefully is a sort of helpful summary of how the court actually approaches ADR clauses sort of in recent times, and sort of gives you a flavor of when it might strike it down. We're now moving on to another thing which courts might or might not strike down, which is a bit different, which is liquidated damages, and possibly a lot of sort of construction lawyers' favorite topic, as we deal with these sort of clauses on almost a daily basis. Now, I had a few questions, I think, before this webinar about the sort of scope of the sort of the new tests for the adoption of penalties, and also whether the court's approach to enforcing liquidated damages has changed over the past few years in light of all the case law which has come out. So hopefully, this sort of next bit will be quite helpful to some of you in practice. But just to recap before we go into the more recent cases, as a lot of you have known, in 2015, the Supreme Court in the Cavendish Square McDessie decision actually reformulated the test for the adoption of penalties. So now, rather than the previous Dunlop test, which was to look at whether something is a genuine pre-estimate of loss, you now look at whether there's a legitimate interest being protected by a particular clause, and whether that sort of clause trying to protect this legitimate interest is out of all proportion to the interest. And if it is out of all proportion, then it will be penal. But essentially, what all of this says is, to put it sort of very mildly, is that the court would actually strive not to strike down something as penal unless they really have to, unless it's really clear that it's disproportionate. And I think that is really the running theme to bear in mind when you're looking at the sort of cases which came out from sort of the TCC since the Cavendish Square decision. And it's actually not really new in a sense, because the court has very rarely struck down clauses as penal, but they have done so for some clauses which are deemed to be uncertain or inoperable in some occasions before. But we can see now actually that in modern times that is even less likely. So the first case I want to mention is actually not a case from the past year, but I think it's important to bear in mind for context, which is the 2021 decision of Equal World and Ballamore. Now, in that case was about actually a party declaration being sought to strike down liquidated damages for being penal and unenforceable. And the reason for that was that the developer has actually taken partial possession of the project. So part of the project has been sort of completed and taken possession of, and therefore the argument went that the absence of a mechanism to reduce those liquidated damages proportionately meant that the liquidated damages, which envisaged that the entire project was not complete, was actually penal or out of all proportion. And the court considered cases such as Bramwell and Ogden and also other decisions where the court has struck down liquidated damages clauses because there was, for instance, not a sufficiently certain mechanism for deciding when the sort of section of completion or when partial possession has taken place and how that liquidated damages clause actually applies. But the important thing to bear in mind in all of those cases is that those cases weren't necessarily based on the doctrine of penalties. Rather, those cases were largely based on the inoperability of the clause. So it was the inability to apply the liquidated damages rates stipulated by the contract to the sort of the state of completion of the contract, because, for instance, it's been operated on the basis of section of completion, but there's no real sort of liquidated damages rates tied to the different sections, for example, or there's no way to decide which section was complete or not. So those were the contexts in which previous decisions have tried to strike down certain LDs clauses. But in Equal and Ballamore, that problem didn't really arise because there was a single liquidated damages rate, which is stipulated for the whole contract. The mere fact that partial possession may have taken place doesn't mean that that single rate of LDs didn't apply. And Mrs. Justice O'Farrell emphasized that, in fact, when the parties fixed that single LD rate, they envisaged that unless you've completed the whole of the works, that rate would apply. So even if partial possession took place, that didn't mean that the rate didn't apply. And in a sense, freedom of contract, it is what it is. And the court was not going to help a party or save them from a bad bargain. So quite a strong decision in terms of basically confining the scope of sort of scenarios in which the court would actually strike down a clause as either penal or as inoperable. And this is, I think, quite important to bear in mind, and for a very important context to bear in mind, particularly when we look at the next case, which is a more recent case from the past year, the case of Buckingham Group and Peel. And this is a slightly different case because although partial possession was an issue, the main issue in this particular case was actually the drafting of the liquidated damages clause in question, because the liquidated damages clause in question actually contained numerous drafting infelicities. So we're talking about a standard JCD contract which has been amended, but instead of the usual just the sort of fixed rate of liquidated damages which is stipulated in the contract particulars, the parties have actually agreed to a set of milestone completion dates or section of completion dates against a set of rates of liquidated damages applicable to each of those milestones. And that schedule has actually been appended to this standard JCT contract. But the problem is it's actually headed as a sort of LAD's proposal. So the impression given was that this was actually just a draft during negotiations, which was never agreed. And one of the problems as well, if you start digging deeper and looking into the schedule, is that this schedule contained multiple liquidated damages rates, multiple sets of LDs, multiple sets of completion dates. And you've also got different sort of contract sums because this was very much a document used during the pre-contractual negotiations. And despite all of this, despite all of these sort of apparent ambiguities, the court actually decided that nonetheless, this was all enforceable. There were sort of sufficiently certain liquidated damages agreed between the parties, which the court was prepared to enforce. The reason being that even if the table was entitled LAD's proposal, the court actually went behind, quite extraordinarily, went behind the pre-contractual correspondence and looked at the context in which this was incorporated into the contract. This was sort of almost like an exception from the usual rule that the parties, that the court would normally not look at pre-contractual negotiations when interpreting a contract, because the court considered that this was not so much relied on as an interpretation of the meaning of the contract, but rather in terms of understanding the background, the factual matrix of why certain documents were incorporated. So the court looked at that context and considered that it was very clear that the parties actually negotiated on this basis and agreed a certain set of rates in this proposal, and then therefore this proposal was appended to the contract. Then looking at it, it is quite clear that it was the second or the last set of rates set out in this table which was agreed on, not the first set of rates. And on that basis, it was clear that the parties, first of all, agreed to a set of milestone dates. They've agreed to a set of liquidated damages rates which was applicable. The basis on which these rates were calculated, although they can't necessarily be tied to the final contract sum, doesn't really matter, because the liquidated damages are the liquidated damages. It doesn't necessarily have to be calculated on any particular basis. So on that basis, the court rejected all of those sort of arguments based on the apparent ambiguities. And interestingly, it went on to decide whether the partial possession was an issue. Now, unlike in the first case, in Equal or Ballimore, the court actually considered that because there was a set of milestone or sectional completion dates, the standard JCT clause for the reduction of liquidated damages for partial possession didn't apply, because that only contemplated a circumstance where there was a single rate of liquidated damages, not a set of rates. So therefore, that was sort of inapplicable or inoperable in the circumstances. That, however, didn't mean that the conclusion was materially different in the end, because the parties didn't actually argue that without a reduction for partial possession, the liquidated damages were penal. So without that contention, in fact, whether the partial possession actually affected the liquidated damages rates was somewhat academic. So I think this, again, sort of just shows you that even where there is partial possession, even where there are drafting infelicities, the court is, again, still striving to give effect to the liquidated damages clause, unless there is very clear evidence adduced by a party to show why they would say that the liquidated damages are penal because, for instance, they're out of all proportion. And I think a lot of us can agree that in most cases it will be quite difficult to find evidence in that regard, or to adduce evidence in that regard. So quite unlikely, I would say, that a court would actually strike something down as penal, and it would take something quite extraordinary or exceptional on the facts in order to persuade the court to do so. Very finally, just a very brief point on liquidated damages and whether they are enforceable upon the termination of contract. Now, I don't really have to repeat the point about the Supreme Court decision of Triple Point from 2 years ago, because I think a lot of you have already done that particular topic to death. So it should come as no surprise to all of you that since Triple Point, liquidated damages are, at least the orthodox position is, that liquidated damages remain enforceable as long as they've accrued up to the point of termination. And then post-termination, one can claim sort of general damages of common law in the usual course. This particular principle, if it was ever in doubt, has now been applied also in the lower courts. So the TCC decision of Energy Works Hull and MW High Tech is an example of that principle being applied really without very much question. This was a case that I was personally involved in because it was a 5-week trial, which was, I think I remember, just after the COVID lockdown ended, in fact. So we were the first ones back at the Rose building. So that case is still very much fresh in my mind. And it involved quite a lot of different issues, not just on liquidated damages and delay. There were issues about repudiation, termination, causation, and sort of quantum and defective works, and sort of exclusion clauses and willful default as well. So basically everything that you can think of in a construction dispute has arisen in that particular case. So I would recommend that you go offline and read at least parts of that if you are interested. But the short point in relation to liquidated damages from Energy Works is that the parties actually tried, or at least one party tried to argue, that the liquidated damages clause didn't apply because of the termination. That was relevant because in that case, the termination arose as a result of a liquidated damages cap being reached on a project due to the contractor's delay. But the argument, so it went, was that the liquidated damages ceased to apply and therefore no liquidated damages were payable because of the termination. I should add that that argument was run at a time when Triple Point hasn't come out yet. So, but unfortunately, even though the Triple Point decision came out halfway through to the decision, or halfway through the trial, that argument was not actually dropped. So it actually probably comes as no surprise that when you come to the decision itself, Mr. Justice Pepperell had very little difficulty rejecting that argument and saying that if that argument were correct, it would simply render the liquidated damages clause of little commercial value. So similar to what Lady Arden and the others said in the Supreme Court decision in Triple Point. So that point, I think, is really now well and truly dead if that argument ever still arises, unless the contract provides expressly that liquidated damages do not apply upon termination. So that's all I want to talk to you about in regards to liquidated damages. Still on the topic of delay, but slightly different, is the issue of causation. And I should say there's not too much by way of update, but I think there's just one particular point I want to highlight in respect of concurrent delay, which is a perennial problem for any construction law or indeed any delay experts or any tribunal has to decide an issue of concurrent delay, because I don't think any two experts or lawyers can actually agree what concurrent delay in fact means. And that's very clear if one even just looks at the case law from the previous years, where you've got the more sort of orthodox, what is the so-called Malmaison approach, where you would say that a contractor is entitled to an EOT if there is both a non-culpable event and a culpable event, and both of them are concurrent. And then you look at later cases from the commercial court and the TCC, such as Edyard and also Jerem Volkes, where the court has actually taken a slightly different approach and said that where there is both an active prevention from an employer, so a non-culpable delay, and also a contractor's own culpable delay, and they cover the same period, then the employer's delay didn't actually cause any delay, actually, and so no EOT is due. So two competing schools of thought, and there is actually as yet no real authoritative determination of which line of authorities is correct, or how you reconcile those two apparently inconsistent lines of authority. Then, quite interestingly, again, like London buses, you get two decisions from the TCC last year, which actually tries to deal with this question. But the interesting thing is that in both of these decisions, those comments were obiter. So I would take all of this with a pinch of salt. But the short summary of these two cases, so you'll see that on your screen. The first case is the Thomas Bond and Blackburn case. The other one is the Energy Works Hull case, which we already just looked at a moment ago. In both of those cases, the court actually adopted the sort of simpler Malmaison approach, the more conventional approach, which is to grant an EOT if there were both a culpable and a non-culpable delay event, and both of them covered the same period. Now, in Thomas Bonds, there were two critical delays, which were sort of one of which was non-culpable and one of which was culpable. And effectively what happened was that the parties agreed or conceded before the judge that the Malmaison approach applied. Now, why the parties actually did that, is probably something which is down to strategic reasons, or perhaps they were trying to narrow down the sort of differences between the parties. But that was the basis on which His Honour Justice Stephen Davies basically said that the conventional approach was the Malmaison approach. So if you have two delay events, one of which was culpable, the other was non-culpable, the non-culpable delay was still an effective cause of delay, and therefore that would give rise to an EOT entitlement. And on that basis, he granted an EOT in that case. But as I said, because that point was not fully argued, those observations on relevant principles were at best obiter in that sense. So we then move on to the Energy Works decision, where in that case, there was an argument as to whether MW as the contractor was responsible for the delay because they were trying to rectify their own defective works, or was it the employer or the owner of the project who was responsible because they failed to provide the correct quality of RDF, or refuse-derived fuel, for the contractor to commission a waste-to-energy plant. And in that case, again, Mr. Justice Pepperell actually just proceeded on the basis that the Malmaison approach was correct, and that M&W would have been entitled to a full EOT if one of the concurrent causes of delay was a non-culpable event. This issue, again, was not really very fully argued in detail in this case, because really, I mean, from the developer or the owner's perspective, the critical delay was quite clear, and that was the defective works. And actually, in the decision itself, Mr. Justice Pepperell didn't have to decide the issue, because he actually concluded on the facts that the critical delay was really the defect rectification works. So it wasn't the non-culpable event in any event. So again, these observations were at best obiter. So it's interesting that you've got two TCC decisions all of a sudden which simply just applies the Malmaison approach without even considering other cases such as Edyard or Jerem Volkes. But whether this is the final word, I think I would just sort of sound a word of caution, because ultimately these are sort of dicta from the court based on a point which has not been really fully argued before the court. So it may be that if this comes before another judge or another tribunal, or indeed if it comes before the Court of Appeal, a different decision might be reached. So probably take it all with a pinch of salt. And if any of you have answers on a postcard, by all means, I would welcome that after this webinar. So I think that's enough on sort of delay, both liquidated damages and causation. We're now moving quite swiftly into something quite different, and we're talking about fire safety and structural safety defects. Now, some of this might be more relevant to those of you who are practicing in the UK as far as the Defective Premises Act is concerned. But there are also principles from the cases which are relevant to more sort of general building disputes in whichever jurisdiction you're based in. So I would say that this is actually of wider relevance to all of you. But just to recap the context of all of this, I'm sure that for those of you who are based in the UK, you've already done Building Safety Act 2022 to death. So I wouldn't want to sort of repeat too much of what you already know. But basically what the Building Safety Act did, for those of you who are not aware, is that it's created, first of all, a new course of action for the Defective Premises Act, so that it applies not just to the construction of new dwellings, but also to works which are being done to existing dwellings. So that's the first major change. The second major change is that it's extended the limitation period for claims under the Defective Premises Act. So for courses of action which are sort of new, so accruing after the Building Safety Act has come into force, you have 15 years. And then for the limitation period for causes of action which have accrued before the Building Safety Act came into force, so for sort of previous projects, basically, you now have a retrospective extension of the limitation period to 30 years. And that's what you see on the screen in section 135 of the Building Safety Act. And that is really probably the key sort of bit, which is the most controversial, one of the most controversial changes introduced by the Building Safety Act. And it's controversial, unsurprisingly, because it is retrospective. And indeed, the statute is very express that it is retrospective and is to be treated as always having been enforced. So as you can imagine, putting that into context, you've got projects which have been dead for perhaps some 30 years before the Building Safety Act came into force, which have now suddenly been revived for the purposes of claims and proceedings. Documents might have been destroyed, the relevant sort of employees or staff, or who might have either passed away or retired or just left the company. So in terms of evidence and sort of fact-finding, that could pose some challenges if you have sort of such sort of dead claims resurrected all of a sudden retrospectively 30 years later. And the interesting aspect of this particular extension of the limitation period is that Parliament obviously considered or contemplated that this might give rise to difficulties, which is why in section 135 subsection 5 of the Building Safety Act, it said that a court can dismiss an action brought based on the extended limitation period if it is satisfied that this is necessary to avoid a breach of a defendant's convention rights. And by convention rights, they're referring to the European Convention on Human Rights. And in particular, one would be thinking about, for instance, the right to a fair trial under Article 6, for example, or perhaps one of the first protocol, the ECHR, which deals with right to property and right to possession of properties. So that would mean that if you're depriving someone of their property, for instance, by requiring them to pay damages as a result of a financial claim, that could potentially lead to a breach if it's not done in a proportionate way or not done in accordance or with prescribed law. So all of those issues, which are sort of not as familiar to construction lawyers because they are mostly public law concepts, might now be incorporated and sort of dragged into construction disputes because of the Building Safety Act and the way it has extended the limitation period. And so that does give rise to some really interesting issues. And we'll come back to that when we look at some of the cases which have come out of the courts in the past year. But I just want to give you that sort of brief recap of what the Building Safety Act has done. The third and final thing I just want to mention for those of you who don't know about the Building Safety Act is that the Building Safety Act has also created a new remedy for claims under the Defective Premises Act. So basically, it means that you can claim not just against the developers and the contractors and the professionals who have been involved in the project, you can actually go behind them and try to claim against their sort of associated companies, so mostly their parent companies, people with the deeper pockets. And that has been introduced in order to avoid companies from avoiding liability because, for instance, they've set up a special purpose vehicle or an SPV just to do a particular project, and they have no assets and therefore leaving some parties without any sort of remedy. So that is another important change to bear in mind in terms of the Building Safety Act, but we will not go into the detail of that because of the time available in this morning. So with that context in mind, I just want to turn to consider some of the cases which has come out from the courts in the past year in relation to fire safety and building safety defects. So the first case is the URS and BDW case from the Court of Appeal. And a lot of you who are sort of practicing based in the UK would already have heard of this case. Now, this case itself is not actually based on fire safety defects because it actually deals with structural safety defects. But nonetheless, because structural safety defects can also give rise to Defective Premises Act claims, there is also some relevance actually from a Defective Premises Act perspective. But the case itself also extends beyond the DPA because it also deals with a claim which was originally brought in negligence. So it is actually a claim in tort originally. And then the parties tried to amend the pleadings in order to add a DPA claim, not surprisingly, because of the extension of the limitation period retrospectively once the Building Safety Act came into force last year. So dealing first of all with the issues regarding the negligence claim, that is probably something of wider interest to all of you, irrespective of the jurisdiction you're based in. It deals with the issue of what is the scope of duty, or perhaps to look at it differently, what is the sort of measure of loss appropriate in the negligence claim. And the problem in this case was that the property in question has actually been sold on to subsequent purchasers. So the original developer no longer has any interest in the property. So it's been sold on to third parties. But nonetheless, they felt that because of the seriousness of the structural safety defect, they would want to come back and fix them and carry out remedial works. Because first of all, they were worried that they might face potential claims from these purchasers. Secondly, mostly because of reputational concerns. So they came in even though they had, first of all, no right to be in the property to carry out any remedial works, and in fact, probably no obligation to carry out any of these remedial works whatsoever. So the question was, in this case, can a person still bring a claim of negligence against the engineers when they carried out the works without any right or obligation to do so, when they have sold on the property? Now, Lord Justice Coulson dealt with this issue quite shortly and said that basically this was a plain vanilla case of a standard duty of care owed by an engineer to carry out their sort of design properly in order not to lead to defects, and therefore, because they breached that duty, remedial works were required, and therefore this gave rise to loss in a very conventional way. So the fact that the developer had no proprietary interest in the property didn't actually mean that they had no cause of action, and that issue does not even arise, and it's not relevant. The sort of slightly concerning part about this decision, of course, is that the approach which the court actually adopted was somewhat based on the approach that the court has adopted in previous cases where there's a contractual claim. So some of you might remember the St. Martin's property and Robert McAlpine decision, which was a conjoined appeal in the House of Lords with the Linden Gardens case back in the years, back in 1994, actually. And that case was about the principle of transferred loss, where there was a contractual claim, and the question was whether, first of all, the sort of purchasers have, or the developers have assigned their sort of claims to the subsequent purchaser, and where there was no such assignment, and so the purchasers couldn't really bring the claim. Could the original developers actually recover nonetheless, sort of on behalf of these purchasers, because they actually have sold on the property and they do not have any interest in the property anymore, so they have suffered no loss contractually. And the court said that they could actually recover on behalf of the purchasers on the principle of transferred loss, because it was contemplated that the developers were building this building for the benefit of these subsequent purchasers or owners. But that was based on contract law, where there was also a principle that you protect a party's expectation loss under a contract, because the expectation was that the party would perform the contract properly. So that is the measure of loss under contract, and you can justify that sort of exception to the usual principle of, or measure of loss on the basis that there was an expectation loss being protected, even though the property has been sold already. That principle doesn't really necessarily apply in a tortious context where you're dealing with negligence, but that issue has not really been grappled with in the Court of Appeal, unfortunately. So I should add that probably I shouldn't go very much further beyond saying that, because this case is actually now pending a Supreme Court appeal, and I am actually involved in the Supreme Court appeal as we speak, and we're waiting for the Supreme Court to grant permission to appeal on this and other points arising from the case. But suffice it to say that it's probably worth just keeping your eyes peeled for the Supreme Court's sort of hearing and decision, which might come if we do get permission on this case. So this is probably not the last word on this issue. The other issue, which is interesting in this case, which is also relevant, is the sort of discussion about when a cause of action actually accrues in a negligence claim. And Lord Justice Coulson actually said that when you have a tortious claim, which deals with an economic loss, because the design defects actually didn't really manifest themselves in terms of a physical defect, so it was a latent defect, that loss actually accrues upon practical completion and not upon the time when you have, let's say, a financial claim being brought or an economic loss being crystallized in actuality. So it accrues upon PC, almost like a sort of breach of contract claim where the breach accrues upon completion of the works. So this is again perhaps a potentially controversial part of the decision which would merit full reconsideration by the Supreme Court. But for now, this is the sort of last word from a court of appeal if you ever have to deal with such an issue from a limitation perspective. There is then the issue about retrospectivity of the Building Safety Act extension of the limitation period, and that really goes deep into sort of Building Safety Act territory and DPA claims. And the reason that this was argued in this case was because, as I've said earlier, that there was an attempt to amend the pleadings in order to add a new DPA claim, and that was brought in the middle of ongoing litigation. And the argument was that the retrospectivity of the Building Safety Act shouldn't apply because it shouldn't apply to ongoing litigation, and there is a usual common law presumption against retrospectivity of legislation in respect of ongoing litigation. The court rejected this argument and said that the retrospectivity actually applies across the board, irrespective of whether there was ongoing litigation or not, as long as that litigation has not been finally sort of determined or settled. So on that basis, the retrospectivity argument was also rejected. There was a further argument which was basically in respect of the scope of the DPA as to whether it applies to individual purchasers only, or does it actually go beyond that and apply to developers as well. And the court had, again, no difficulty saying that the DPA actually applies to both individual purchasers and developers who have commissioned the project. So it's not confined to sort of homeowners, essentially. And again, that argument that only the developers don't have a right to bring a DPA claim, that was rejected. So all of that meant that this case was one of those cases where the court was going to allow the DPA claim and the negligence claim to go forward, so that is also one of the reasons why the parties are quite keen to sort of resolve some of these issues by bringing a further appeal in the Supreme Court. Quite a lot in this one sort of tiny little decision. It's not actually tiny because this decision actually runs to 200 odd paragraphs. So something that I would say, worth reading offline for sure, for those of you who are involved in defect claims and those of you who have issues relating to the scope of duty and limitation. And as I said, stay tuned for anything which might come out of the Supreme Court if we do get permission to appeal. The other very interesting case which came out from last year in relation to fire and building safety defects is the Lendlease construction and AECOM case, which is a TCC decision this time, not from the Court of Appeal. This one relates to fire safety and M&E defects actually in a hospital in Leeds. And this case deals with quite a few issues in relation to limitation and also scope of duty. And I think that is also sort of worth covering and is of wider interest, not just to those of you who are based in the UK and dealing with Building Safety Act claims. First of all, in respect of limitation for contractual claims, the court very helpfully sort of clarified the the point at which defective design would accrue as a contractual claim. And it's worth bearing in mind that although some people might think that usually for contractual claims, the claim sort of accrues at the point of practical completion, when it comes to design claims, actually, it accrues at an earlier point of time when the design was actually handed over for construction. So that's the first important point. The second important point is that even if you have a sort of particular contractual provision which says that claims cannot be brought later than a certain period of time, let's say 12 years, that doesn't necessarily mean that it replaces the statutory limitation period, because it can simply take effect as a long stop, but it doesn't actually oust the statutory limitation period. So if it's a simple contract, it's still the usual 6 years. If it is a deed, then it would be the 12 years. The interesting thing in this case, of course, is that there wasn't there was some dispute about whether there was a contract or a deed, because the signatories who signed the deed didn't actually have the authority to execute that document as a deed, because they were not statutory directors. But nonetheless, because those directors helped themselves out and AECOM held those signatories out as authorized signatories, they were actually stopped from contending that they didn't have the authority to sign it as a deed. So that was still considered to be a deed, even though the signatories were not properly authorized. So quite an interesting case about the execution of deeds. We don't come across that very often. The other aspect which is interesting from the Lendlease and AECOM case is in terms of the scope of contractual duties owed by a professional, which in this case was AECOM as the engineers. First of all, the important thing to bear in mind is that there is usually a sort of almost a right or entitlement for a professional to rely on third-party specialists because they can't do all parts or all aspects of the design of their own. So that itself is not a problem. And the court confirmed that the engineer, AECOM in this case, was not obliged to duplicate the works which are done by a specialist. So in terms of the standard of care that they owe, if they delegated some of the works to specialists, as long as that was reasonable in terms of the delegation and the specialist did carry out those works, it's not unreasonable that the engineer did not sort of duplicate or check every bit of those works. There is also the question of whether when you have a sort of usual standard of reasonable care and also some stricter sort of prescribed design criteria, in those circumstances, whether there's a strict warranty that the design criteria would be met. So some of you would remember the Supreme Court case of MT Hogarth from a few years ago. So this is a similar type of issue. But interestingly, the court said that in this case, just construing the contract in context, actually, the prescribed criteria was not a strict warranty or guarantee that the criteria will be met or fit for purpose, but rather that provided the context of whether the duty of care has been discharged. So the failure to comply with certain sort of stipulated regulations might mean that the duty of care has been breached, or might mean that the duty of care owed would require certain considerations to be taken, but that doesn't mean that there is a strict warranty. The final important point from this is the sort of more common question, which is whether there is a duty to review a design. And that obviously can be quite helpful if you have limitation issues, if you want to postpone the accrual date of the design of the course of action because you say that there's a later duty to review the design after the design has been completed. But the long and the short of it is that unless the contract actually provides for some duty which goes beyond the supply of the design, you don't actually expects the contract to contain a duty, even an implied one, to review the design once that design has been completed and supplied. So if you have a professional appointment which actually requires the architect or the engineer to, for instance, supervise the works or sort of carry on advising on the project during the course of construction, then one might, depending on the context and the terms, be able to find some form of duty to review the design if a reason for reviewing the design arises. But other than that, in this particular case, for example, no such duty, no such continuing duty would normally arise. So I think the scope for actually trying to imply a duty in order to try and avoid a limitation issue is actually quite limited. So quite an important sort of cautionary tale. So that's Lendlease and AECOM. Just one final point about fire safety defects. I won't dwell on this too long. There are two decisions from 2022 from the TCC in relation to fire safety defects, the Martlet Homes case and the LDC and George Downing case. And those are probably the first two TCC decisions relating to fire safety defects since the Grenfell Tower dispute. Those two disputes, interestingly, were sort of decided on a contractual basis. So it really was based on contractual warranties, either in respect of the compliance with building regulations or in respect of very specific criteria on a fire safety design. So very limited in that sense. But what is worth bearing in mind that in the Martlet Homes case, though, the court did have some interesting observations, obiter observations, about whether there would be a breach of a duty of care, for example, in failing to consider certain sort of industry guidance or building regulations in relation to fire safety. And the long and the short of it is that the court is not sympathetic with any arguments that everyone else or every professional in the industry was doing the same thing or assuming the same thing to be safe, because that is not an excuse for not at least asking the question and trying to ascertain whether certain sort of criteria has been met in respect of fire safety, or certain materials or cladding systems have passed the sort of relevant tests recommended by the British standards. So the sort of everyone else is doing it defense would not probably go very far if you are dealing with a building safety claim. The other thing to bear in mind from the Martlet Homes case is the issue of causation, because In fact, some I've seen in sort of the past few years, one of the most sort of popular defenses run by contractors who are faced with these claims, or developers faced with these claims, is that there's no causation because the sort of building owners or the sort of leaseholders are actually required to do the defective premise, to do the defect rectification works in any event because of the sort of updated building regulations. So they are required by law to actually make the building safe for other reasons in addition to the defective works. But, you know, it's probably unsurprising to all of you that that sort of argument would not go very far, because in any event, the defective works were an effective cause of the remedial works. So even without the building regulation changes, those defective works would have required a remedial solution. So the court was not going to apply a strict sort of but-for causation and shut out all of these claims, but rather the courts have shown quite a lenient approach, and they have been quite sympathetic to claims being brought in fire safety defects. So if you are advising a client on the defending side of a sort of fire safety defect claim, then the Martlet Homes case and also the LDC decision, those are decisions which I would recommend that you read in full offline, just to understand the court's approach. So finally, now we're sort of reaching almost the end of this hour, but just a final sort of topic on the enforcement of adjudication decisions. For those of you who have who do not sort of practice in adjudication or are in other jurisdictions, you might find that this is less relevant. So, you know, if you need to sort of drop off sort of early, then by all means, that is understandable. But for those of you who do adjudications, there are a few cases which I just want to mention to you to bear in mind over the past year, which I think are noteworthy. First of all, one of the things which comes up quite often in adjudication is the use of Part 8 claims to try and resist enforcement. So using a Part 8 claim to basically seek a final declaration on, let's say, a contractual interpretation issue in order to trump the decision of an adjudicator. The one interesting case from the Court of Appeal last year was the A&V Building Solutions and J&B Hopkins case, because it did consider the circumstances in which a Part 8 claim would be appropriate and when the court might prevent a Part 8 claim from proceeding where there is a concurrent adjudication. The slightly unusual aspects of this case is that the Part 8 claim, rather than being started after the adjudication decision came out and used as a means of resisting enforcement, the Part 8 claim was commenced during the adjudication whilst it was still ongoing. But the court had little difficulty saying that here, actually, there was nothing which prevents a party from doing so. It might be costly, it might not be very wise, but the parties are entitled to start a Part 8 claim at any time. And in this circumstance where after the adjudication decision has come out, what a court dealing with this issue should think about is, first of all, consider whether the adjudication decision itself is enforceable. That's the sort of first logically prior question. And then you move on to the second question, which is, even if the decision is enforceable, would the Part 8 claim actually trump that adjudication decision because the court actually would reach a slightly different decision from the adjudicator's findings? So that would be the usual sequence in which the court should approach the question, and that's actually very helpful guidance, and that guidance has been relied on and cited in other TCC cases in the past year already. The other interesting thing to look at, and I wouldn't go into the detail at this stage, is the sort of point of interpretation which was considered in this case, because it considered the sort of interpretation of a payment schedule and whether a payment application was invalid because it missed a certain payment application date. And the short answer is that the court actually decided that it didn't, so the payment application was not invalid, and it was valid because it construed the payment schedule in context to find that the payment application dates were not meant to be sort of a condition precedent or a fixed date. So even if the payment application was brought at a slightly later date, as long as it sort of met the other conditions or criteria in the rest of the contract, it was still valid. And in any event, because that particular payment application has been treated as valid by the parties over the course of months, actually almost 6 months, the court was actually prepared in any event to find that there was some form of estoppel which prevents the employer from saying that the application was invalid. So that itself is quite an interesting decision in various aspects from a sort of adjudication point of view. It's worth contrasting that against other cases where the court has decided not to allow the use of a Part 8 claim to resist enforcement, and the Martlet Homes case would be a sort of interesting case from that perspective, because that was a case which was about a contractual interpretation point, but the court decided that the Part 8 procedure was not appropriate because the court would have to go too much into the factual matrix to understand whether the parties have actually sort of carried out certain parts of the design and what they contemplated or understood in terms of the sort of status of the design and the responsibility for the design before entering into the contract in order to interpret the contractual provisions. So because of that sort of disputed fact, that was too complex for a Part 8 dispute, even though it ultimately went to a point of contractual interpretation. So just bear in mind that not every point of contractual interpretation would be appropriate for being dealt with on a Part 8 application. The other issue, which is also quite sort of frequently encountered in adjudications, is in fact serial adjudications. So if you have more than one adjudication, then the question arises sometimes as to whether the prior adjudication decision is actually binding in a subsequent adjudication decision. Now, the first case, Essential Living, was a case which I did last year, and that was a Part 8 claim for declarations to the effect that because there was an interim valuation adjudication which took place before the final accounts, by the time you get to the final accounts, you can't actually re-adjudicate some of the same claims which have already been sort of determined by the prior adjudicator, even though in the context of an interim valuation. And the important point coming out of that is that Mr. Justice O'Farrell actually agreed that insofar as you have the same, let's say, variation claims or the same sort of contra charges which were already determined in a sort of interim valuation dispute, particularly one which was quite close to practical completion, you can't just try to reopen that in the final account adjudication just because a final account dispute is different. So that was Essential Living in Elements from 2022. This year, there was a Court of Appeal decision, Sutlows and Global Switch, which came out, which also deals with a similar issue about serial adjudication, but this time on the question of whether a prior adjudication on an EOT is binding on a subsequent adjudication on sort of claiming further EOTs and loss and expense on the same grounds. And the short answer is that the Court of Appeal actually decided that because the prior adjudication has already decided that a particular delay event was the critical cause of delay, and that was the basis for the EOTs granted, in the subsequent adjudication where further EOTs and loss of expense were claimed on the basis of the same delay event, it's not open to the adjudicator to reassess also reopen the issue of whether the cause of critical delay was in fact such a cause. And so that was basically an extension from the further adjudication, and the adjudicator was bound by the finding in the first adjudication as to what was the critical cause of delay. And the important thing was that in this case, if one looks at the evidence, it was basically an extension of the evidence in the first adjudication, the same claims and the same delay events. So that was the reason why the court found that the second adjudication was bound by the first one. One point as well, which is worth remembering from the sort of from 2023, is the set-off sort of different adjudication decisions. And in some cases where a party tries to resist enforcement, they try to set off different adjudication decisions against each other. But the important thing to remember procedurally is that from the FK Construction ISG case from 2023, if you are trying to set off different decisions, you would need to at least have enforcement proceedings started for each of those decisions so that the court would have an opportunity to decide whether each of those decisions are actually enforceable or whether there are just jurisdictional issues or natural justice issues. So you can't just all of a sudden from your back pocket pull out 3 or 4 different decisions in order to try to set it off against a decision which is being enforced. So bear in mind that that is the procedural requirement, and the court would not in every case set off decisions simply because there have been serial adjudications between the parties. So we're reaching the penultimate point on adjudication decisions, and that is the sort of the timing for a true valuation adjudication where you are dealing with an interim account. And of course, a lot of you would probably remember sort of the Grove and S&T decision, which decided that in order to have a sort of interim sort of true valuation adjudication, normally you would need to have the sort of Sebastian Grab adjudication decision either paid off, or you would have the notified sum paid off already before you actually do the true valuation adjudication. But as long as you've done that, there is a right to actually refer the true valuation of an interim account to an adjudication. But the important thing is the timing, because in 2022 and in 2023, so the Beck's Heat case and the Henry Construction case, those 2 cases effectively confirmed that unless you actually have a sort of, you have actually already paid the notified sum under the payment application, or you have already paid the award of a smash and grab adjudication, you cannot actually start a new true valuation adjudication on that basis. And if you do that, the problem is that the adjudicator would actually lack jurisdiction, and therefore the true valuation adjudication would not be enforceable. So something to bear in mind if you are, again, in a situation where you have to deal with serial adjudications in relation to one interim valuation account, the timing is absolutely crucial. So the last point I want to talk to you about this morning is just a very short point, which is whether you can actually resist enforcement of a decision where an adjudicator has tried to demand payment of some of their fees before the decision was delivered. And that argument was run in the Nicholas James Kerr case in the TCC decision this year. And the problem in this case was that the adjudicator actually required the parties to pay a deposit and also pay a sort of further deposit before the decision was released. But the short sort of decision from the court was that even though there were persistent requests for this sort of payment before the decision was released, that was not considered to be a lien over the decision, which was impermissible. But because it's not really a lien, it's actually justifiable for the adjudicator to impose this sort of requirements. This was not a ground for resisting enforcement. Now, query whether actually this actually gives rise to some issue of natural justice, because in some instances where the adjudicator requests payment from a party before releasing a decision and a party has historically not paid that sort of fee before the decision was released, there have been concerns about sort of potential issues of bias and natural justice, but that issue wasn't really considered in this case. So I think the issue is that the court is still very much inclined to enforce adjudication decisions if they could, just as they would, again, enforce arbitration awards wherever they can, and they're very reluctant to strike down an adjudication decision. So that probably explains why the court was not very sympathetic with this particular argument on this occasion. So on that note, that really covers, I think, everything that I want to cover with you this morning in respect of the sort of developments over the past year in 2022 and 2023. I hope that has been helpful. And for those of you who still have a bit of time, I'm conscious that we are sort of a bit past 9:30 now. But if you do have any questions at all, feel free to sort of ask them now. But I can also see that there are sort of one or two questions which have come up on the Q&A. So I will try and answer them. If you do have to drop off, obviously you will still have the recording, so you can perhaps sort of just fast forward to this bit and sort of watch this bit of the Q&A if you do want to sort of tune in afterwards and you have to shoot off somewhere else. So just looking at the questions, first of all, the first question which come up is in relation to the DPA, which is if you are dealing with a DPA claim, particularly under the BSA with the extended limitation period, and you have to sort of bring an ECHR defense, so a defense, let's say, based on Article 6 of the ECHR, the question is, what sort of evidence do you need in order to prove a breach of natural justice? Now, I confess I'm not a public lawyer, so I'm not a specialist in this type of argument, but I would imagine that in this sort of case, sort of based on the experience of sort of cases that I have dealt with from a construction context, one would probably imagine that you would need, first of all, evidence of why, let's say, certain evidence that might have been available had the claim been brought 30 years ago, or at least sort of within the original limitation period, why that sort of evidence is no longer available, and why that would be sort of prejudicial to the party. So you need two things. So first of all, you need an explanation, probably some form of witness statement, explaining who the people were at the time who were involved in the project, why those people were no longer available as witnesses, and then secondly, as well, relatedly, why certain documentary evidence such as the contracts or sort of project correspondence, why that has not been sort of retained, or sort of why that is no longer accessible or in the custody of a party as a result of the sort of lapse of time. So you might need an explanation of the sort of documents retention process within the company. You need some evidence to that extent, potentially. And then finally, you will need some evidence to explain why that would be prejudicial. And that potentially might not be as much a point of evidence, but more a point of submission. But effectively, you need to explain to the court why, without that evidence, you as a defendant in the claim is unable to actually sort of put forward a proper defense, or to have a proper opportunity to put forward your case and sort of make representation, because that is the sort of core right under the Article 6 of the ECHR, which is to have the right to fair trial and the right to properly present your claim. So that is really, I think, the sort of thing that you need to think about. I've got another sort of question here, which relates to sort of concurrent delay, and the question goes this, I'll just read it out. So an arbitration tribunal has recently decided as part of its award that bonds its authority for the position that the timing of the commencement of the delay periods is not relevant, and that provided that there is a period where the culpable and non-culpable delay occur at the same time, that is sufficient. So the first in time principle does not apply. Is that my view? Now, I think, I think what is slightly unclear from the decision, because, as I've said just now, some of these sort of observations were obiter, is that it's not very clear what sort of principle it actually stands for, if any, or at least whether it's sort of binding authority for any real principle. But I think what it does show is that where you have sort of two delay periods, which basically sort of ends at the same time. So they're looking not so much as the sort of starting point, but looking at the end point. So if you have two concurrent delays, which delays the completion to the same point in time, and those are concurrent, then whether it starts at the same time is slightly irrelevant, but rather actually you just look at whether those two causes are both effective causes of delay. So I think to that extent, you can say that that decision does sort of reach that sort of conclusion on that basis, based on the Malmaison approach. But again, as I've said just now, whether that is really binding authority for that principle, I'm slightly dubious, and I wouldn't be too surprised if another tribunal, having heard an argument on other decisions, actually reaches a slightly different conclusion on either the sort of first in time principle or on the sort of general sort of causation, effectiveness of the cause, and concurrency issues. So I would say that, again, if you were arguing a point about that, then probably try and bring to the tribunal's attention the other decisions coming before that, which did actually consider the issue more fully. And I think that would probably be a better way to go with, rather than just relying on this one or two isolated decisions from 2022. So I think that is really the time we have this morning for all the questions. Thanks very much, everyone. I'm assuming that's really sort of, I think that's been helpful, actually, both the questions and also I'm hoping the talk itself has been helpful for all of you as well. As I've said, feel free to share the recording. We will actually provide you with a recording afterwards, so feel free to share it with your colleagues, and hopefully I will see all of you very soon on another occasion. If you have any other questions that you want to send me by email, feel free to get in touch, but otherwise I will see you at the next webinar. Thanks very much and take care.